all occupants of 1790 Hamlet Drive.
Thank you, Your Honor. Attorney Paul Spaniolo, my P number is 72366, and I'm here on behalf of the plaintiff, Judge.
All right, have you seen any of those individuals here?
Not at this hearing, Judge. Your clerk will tell you they've been at the previous ones on Zoom, but no one's checked in today. I've called out the name and no one's responded.
Have we didn't have anybody?
We didn't have anybody check in today, no.
Raise your right hand if you'd like to take a default. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Judge.
Go ahead. State your claim.
Your Honor, at this time, I'd like to move for a default judgment. This was a summary proceeding for a recovery of possession subsequent to the expiration of the redemption rights. You'll see attached to the pleadings an affidavit that identifies that the redemption expiring, I believe it was November 25th.
Yes, sir.
We filed this matter after, as I stated, someone appeared. I believe the first name was Mary at some of the hearings. Tried to work out a resolution with them. It's my further understanding that there's no one in the house that is an active member of the military service, and I don't believe, to the best of my knowledge, that there's any minors in the home.
All right, very good. Based upon that testimony, court will issue a judgment by default for possession. No redemption amount, writ issue in 10 days. I'll sign the
Thank you, Judge.
judgment.
You and your staff have a wonderful day.
You do the same.
Thanks.
Court does call the case of Six Trails versus Jordan Oren.
Good afternoon, Judge. Joe Joseph for the plaintiff.
Your name, sir?
Jordan Arn.
All right, and where are we on this case?
Judge, we are showing a balance of $3,267 plus the court cost of $177, and that totals $34.44.
Did you pay the $1,000 that you said you were going to pay?
No, I actually just got paid yesterday. I haven't had time to pay anything yet, but my dad is willing to help with a portion. So I was hoping to have I get paid again 2 weeks from yesterday. So 2 weeks Thursday. So
The
from
12th?
Sorry, I don't
So you get paid on the 12th.
Yes, should be the 12th. Yes, that sounds right.
So with what you have now, what your dad's going to give you and what you get paid on the 12th, you're going to be able to pay this all off?
Should be able to. Yeah. All right.
And that total
very
amount
close.
that's owing is 34.44. What's the change on that? Is there any?
No change, Judge.
No change. Court will find no tribal issue after hearing. I'll issue a judgment for possession in that amount. However, given his pay, the writ would normally issue on the 9th. The writ will issue on, I'll just make it the 13th so he can get his check, get down there and get it all paid off. So you have till the 13th of February to pay that off. Understand this judgment does not include your February rent.
Okay.
Understood?
Yes, sir.
All right, thank you.
Yeah.
Thank you, Judge. We'll
Great
submit that to
Arbor
the court.
Properties versus. All right, take care.
You too.
Great Arbor Properties versus Ann Ekafina. Finwa.
Good afternoon, Your Honor. For the record, Stuart Collins on behalf of Great Arbor Property.
She did not check in. All right, she did not check in with us. If you'd like to take a default, raise your right hand to be sworn.
Thank
You
you.
solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
All right, what is your claim?
Your Honor, we are asking for a judgment in the amount of $15,218.55. Rent due at this time is $14,370. There's a past due water bill of $672.47. That totals $1,504.2.47. Court costs of $101.08 and the statutory attorney fee of $75. That's a total of $176.08 in court costs, which again brings a total of $15,218.55.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days.
Thank you very much, Your Honor.
Thank you, sir. Martin Ryan versus Tamika Sims.
Again, Stuart Collis on behalf of the plaintiff in this matter.
Neither party? Oh,
Your Honor, I'm
Collins is
plaintiff
here.
on this one.
Yes, I got you. Tamika Sims, not here. You may proceed.
Again, Your Honor, under oath, there is $9,179 due in past due rent, court costs of $161.45. Statutory attorney fee of $75, bringing a total to $9,415.45. We'd ask for a judgment in that amount for possession and the money judgment. I believe this was personally served.
Nobody checks in and the judge goes, all right, default. First case, foreclosure possession granted, writ in 10 days. Next case, the tenant admits he hasn't paid yet, but says his dad will help the judge give him until February 13th to pay it off. Then another no-show hits for over 15 grand, and the court grants judgment by default again. Moral of the story? In court, silence isn't safe. It's a loss.
I do have personal service. Judgment to the plaintiff. That is by default for possession and money. Redemption amount and money judgment in the amount requested with the writ issue in 10 days.
Thank you very much, Your Honor.
Court
Have a
does-
good day.
You do the same, sir. S&C Holdings versus Lori Ann Pearson.
Ready, Your Honor.
Pearson did check in, she was physically here somewhere, Your Honor. But she was also told we would be delayed.
She was told we'd be delayed.
That's correct, yeah.
Can you check and see if Pearson, if she's out there?
Your Honor, we could pass if there's an inconvenience.
My whole day's an inconvenience, so, but thank you. All right, so. Pearson? Yeah, I'll pass it. Thank you, sir, and we'll get you called. We'll get you out of here eventually.
Thank you, Your Honor.
Thank you. Westbrook Apartments versus Mary Lee MacArthur. You don't have her.
Good afternoon, Judge Mark Schlesinger appearing on behalf of plaintiff.
Tenant did not check in.
This tenant did not check in. All right. All right, sir, would you like to take a default?
Judge, I believe we already have a judgment. I believe this is a writ hearing that the court scheduled on its own.
I did, you're right. And I did that because it was basically the court costs that hadn't been paid. I don't know if subsequent to that time they paid it or not.
It has not been paid off, Judge, in January. Rent remains outstanding.
Got it. Okay. So hearing held, writ will issue.
Thank you very much, Judge. Have a great day. Have a good weekend, I guess.
Yes, you do the same, sir.
Thanks, Your Honor.
That's got to be processed.
Yeah.
Court does call the case of Clark Road Family Dividend Housing versus Brianna Holcomb.
Good morning, Your Honor. Rebecca Arnold, P72714 for the plaintiff.
Ms. Holcomb.
Good morning, Judge.
Good afternoon.
Oh, yes, good afternoon.
No, it's
Sorry.
okay.
I've been ripping and running. I should have said that.
No, it's okay. All right. What is plaintiff? Where are we on this case?
So it looks like we were previously scheduled on the 16th. It's my understanding that Ms. Holcomb had applied for time or requested time to apply for assistance. I've not had a chance to speak with her, nor has the property as to where she is at this time. So we're here seeking a judgment today.
You had an appointment with Hawk on the 26th.
Yes, and I have another, my follow-up appointment is scheduled for February 10th at 12 p.m.
It's scheduled for February 10th.
At 10 p.m. Sorry, at 12 p.m. 12 p.m.
Did they make an indication or give an indication that they would be able to?
Yes, I turned in the last requirement, which was I had to show proof of a job, and I did get a job. I started Wednesday.
Okay. So let me ask this. What's your monthly rent?
My monthly rent is $206.
This docket is brutal. Name called no response, raise your right hand. The attorney lists the rent, water bills, costs over $15,000 total, and the judge signs a default judgment for possession like it's routine. Then another case, $9,415 due, personally served, still no appearance, default again. You can feel the judge's patience running out as the room turns into a conveyor belt of
206?
Yes.
So
I got sick and my car was down. So I fell behind and I'm a single mom.
it's all right.
Thank you.
That happens.
Thank
But the reason I was asking that is if I adjourn it out, you don't go over 3,000, which would be the cap for Hawk.
Exactly.
Okay, so she'd still be under that cap. So council, what I'm gonna do is I'm gonna give her a shot. She's got the follow-up appointment on the 10th. They're gonna let her know and they may be able to clear everything on her account.
Okay, would we be able to request an escrow for February's rent?
I can do that.
Well, yeah, she could pay that into escrow. No, I understand what you're saying, but what I'm saying is that she will be at about, she's at about 26 now. She'll be at about 28 or so with her February rent. Hawk's cap is 3,000. So if they're gonna help her, they're gonna pay the whole amount in any event. So here's what I'll do. I'll escrow, the issue of escrow is reserved. So I'm not gonna order that you pay it now, but I may order it if something else happens. I'll adjourn this matter out to February 13th. I don't have next week, so I can't do that. February 13th, 2026 at 3 p.m. for an in-person hearing.
Does it have to
You
be?
got your second, it's at 3 p.m.
Okay.
You got your second appointment with Hawk on the 10th. So at that point, we ought to
Is there any way
potentially
that-
know something.
Is there any way we can do this by Zoom for work reasons because it's a brand new job or no?
You want to appear via Zoom?
If I'm able.
You don't want to come down and see me?
I
What
just
you
want
said,
to.
I'm sick of you, Jen Simpson. I don't want to be in your presence. Is that what you're telling me? Fill out the form. We'll consider it.
Okay, thank you.
We understand.
We have
All
no
right,
objection
take
either. Thank you.
Thank you.
Have a great one.
Court does call the case of Huron Vista versus Sabrina Jackson.
Rebecca Arnold, P 72714 for the plaintiff.
She has not checked in. Counsel, if you'd like to take a default, please raise your right hand to be sworn.
This one's a little tricky, Your Honor. We had spoken with Miss Jackson about doing a conditional dismissal.
Got it.
So
You want to adjourn it out then?
let's do that if you don't
All
mind.
right.
I hate
Not
to
a problem.
take a default when we have an agreement in place.
Understood. February 13th, 2026 at 3 p.m.
Thank you, Your Honor.
Thank you. Court calls the case of Huron Vista versus Charday Payne. She did not check in. So you may proceed. If you'd like to proceed with a default, please raise your right hand.
Yes, Your Honor, we would like that.
All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your claim.
There's now due and owing a total of $5,708 in rent, $239.40 in court costs for a total of $5,947.40 due and owing.
All right. Judgment to the plaintiff. That is by default for possession. I don't have personal service, but they were here before.
She did
So
appear
I'll give
previously.
Possession, yeah, possession and money in that amount. By
Thank you.
default with a writ issued in 10 days.
Thank you, Your Honor.
Thank you. Is that it for you?
I believe so.
All right. Have a great weekend.
You as well.
They're ready. All right, let's bring them out.
One tenant actually shows up and says, I just got paid yesterday. I haven't paid anything yet. The judge does the math. $3,444 owed, court costs included. Then he gives a narrow window pay by February 13th or the writ moves forward. It's not a speech, it's not a debate, just a deadline. That's the reality. Once the judgment hits, time starts shrinking fast.
Court recalls case of the people versus Jules Calpo.
Andrew Childers appearing on behalf of the people. Ron Brown appearing on behalf of my client, sure.
Right.
Thank you, Your Honor. I appreciate the opportunity. I've spoken with the chief assistant, the elected prosecutor, and the petition that we are requesting I would call it modified off the written pleading. What the people are requesting is and I don't believe in my discussions with the public defender's office, this is something that they're opposing. The house arrest at the uncle's address on Ingalls, so it would be a GPS tether with house arrest. Commander Shipakasi from the jail has been, or is currently in communication with the deputy chief at Ann Arbor Police and working with the uncle to have Ann Arbor Police go through the residence prior to the defendant being tethered there to ensure there are no weapons in that home. And I believe that we would allow, the defendant has medical appointments at CMH and a doctor. We can figure out those details, but we would allow for release to verified medical appointments from the Ingalls Road address.
Right.
That's correct, Your Honor. We'll hammer out the details and present an order to the court.
Well, you'll figure out the details of the appointments.
We have the appointments in the address. 2 at CMH and 1 with a Dr. Conley, whose office is at 3300 Washington Avenue, right now.
But are those regular appointments? So they're going to occur at a particular time or what?
Through today, for the next week, we know of these appointments. But once he's seen, we don't know of when he will be seen again or scheduled again. They're intake assessments.
Thank you.
And my understanding.
That's right. What did you hear?
I'll go sit down.
What? Oh, no, you're fine. I'm just saying. I knew somebody knew something more than most.
Of course. Usually in my experience, if we allow for them to, there can be an aspect where the defendant is communicating with community corrections.
Correct.
If this particular doctor, I know appointments change and things like that. We don't need to have an order reflecting every single appointment. But the people we would have no problem provided they are verified with the defendant seeking the treatment at CMH and with his doctor.
All right. So just so that I'm clear, the request for the increase in bond, the monetary amount is withdrawn.
They're no longer making that request.
The request for exclusion zones is not needed only because he'll be under house arrest.
Right.
All right. And then what did I say the other one was?
Here's the wild part. Some cases get defaulted instantly, but others get a lifeline. One mom says she's a single parent, her car broke down, and she has a hawk appointment coming up. The judge checks the $3,000 cap and goes, "All right, I'll give you a shot." Case adjourned to February 13th at 3 p.m. In the same courtroom, the difference between default and a second chance is simply showing up.
All right. So really the second one is just a modification of GPS tether to a house arrest.
House arrest, correct.
All right.
And Brandon Casey from Community Corrections was already sending me messages that they're aware of this address and
they're aware of the Ingalls address.
Correct.
All right.
Your Honor, we've also spoken to the owner of the 110 North Ingalls address, and he has consented to the police search of his home for weapons.
All right. And that's a single.
It's an apartment. It's an apartment.
Oh, it's an apartment.